guilty of the misdemeanor. You're sentenced to 6 months probation with JCS. However, your supervision will automatically terminate at the 3-month mark if you've successfully completed all the terms of your supervision at that time and haven't committed any new law violations. You will need to perform 24 hours of community service work, enter and successfully complete the anti-theft course, pay the $100 fine, and pay the court costs. Anything that I've missed from Mr. Scott?
We'll get the prints in within 30.
Yes, sir. Mr. Scott, you'll need to, where will Mr. Scott need to go for the prints?
So we'll work that out with him. He lives in Arkansas, so we'll get him the form and he'll bring it back either through probation or we'll turn it in for him.
Okay. So, Mr. Scott, you'll need to provide your fingerprints within 30 days from today.
And that's
Yes, sir.
That's a condition of probation.
Yes, sir. Correct. Thank you, Mr. Scott.
Thank you. You have a good day.
You too. Okay.
That's all I have.
Thanks, Mr. Gilbert.
Thank you.
Mr. Shaw. Morning, sir.
Good morning, Judge. How are you?
Good. How are you?
Judge Tim Shaw for Sheena Marie Russell. This is set on for a status conference with State Attorney Paul Gillespie. I don't know if he's here or on. Is anybody covering for him?
Is somebody covering for Mr. Gillespie?
It's already been continued to the November date, but I know he had asked for a status call for today.
Okay. Well, since he's not present and since we've got trial next time times 3, I think, we'll be looking at going to trial next cycle.
I understand that. I just want to point out to the court that a week ago today, we received 7th discovery exhibit with a substantial number of new exhibits, attachments, and witness names. So we'll let the court deal with that when the time's appropriate.
I'll make that note.
Thank you,
Good.
Judge.
Thank you, sir.
Thank you.
Mr. Lopello. Good morning, sir.
Permission to approach, Your Honor?
Yes, sir. Thank you. Ms. Sullivan, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, if you can put your hand down. Ms. Sullivan, if we can be a moment.
And I can recite the terms of the court would want me to.
That's fine. I think I can read it.
You got it? Pursuant to an agreement with the state, we're going to enter a plea of no contest as charged, or not as charged, to a lesser included offense on 24 CF 1274, admit the violation on 22 CF 59 with the terms and conditions on the plea agreement.
Okay. Thank you. Ms. Sullivan, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Sullivan, I do accept your plea. Adjudication is withheld in 22 CF 59. You're adjudicated guilty in 24 CF 1274 of the misdemeanor. In 24 CF 1274, you're sentenced to 6 months state probation. That's concurrent with any other sentence. The court waives the fine. Do I have the ability to do that? Yes? Okay. Waive the fine. You'll need to pay the court cost. Take the victim impact panel, attend that. Take the Florida Basic Driver's Improvement course. Have no contact with Chanel. How do you pronounce her last name?
Laranaga.
Okay. And it's Larranaga. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution. In 22 CF 59, again, it's withhold of adjudication. Your current supervision is reinstated with the original terms and conditions. However, it is modified so that you'll need to pay a $100 cost of prosecution, $50 VOP fee. Usually it's just a $100 cost of prosecution. I don't think there's usually a $50 VOP fee, just so you know. So there's not that, just the $100 cost of prosecution. You'll need to perform 24 hours of community service work. Thank you, ma'am. Good luck to you.
That's all I have, Your Honor. Thank you.
Thanks, Mr.
All
Powell.
right, good day.
You too. Mr. Garrett.
Good morning, Your Honor.
Good morning, sir.
Your Honor, I have 3 clients on today's docket. They're all basically set for status. The first is Sergio Quijano Estella, 23 CF 2015. I had a chance to speak with Mr. Snell about this case this morning. We wanted to hypothetically set, well, if it's okay with Your Honor, set that for October 10th for potential resolution. We're still trying to work out a plea agreement.
Okay, so have we already continued it to November 12th?
I don't believe so.
Okay, so the underlying case is continued to November 12th, and you want to set it for a status on October 10th?
Yes, please, Your Honor.
Okay, October 10th at 9 o'clock for status.
And that was 9 a.m., Your Honor?
Yes, sir.
Excuse me. Then Chris Garrett on behalf of Frank Soska, 24 CF 671. I believe the state has his signed plea and sentencing agreement. Your Honor, if I may approach.
Yes, sir. This is for the misdemeanor?
Yes, Your Honor.
Thank you. Thank you. Good, thank you, sir.
Thank you, Your Honor. And then finally, excuse me, Chris Garrett on behalf of Larry Wagner, 24 CF 1557. We'd set this case for today for status to see if we could work out a plea agreement. We're not quite there yet, Your Honor. We'd ask that he be set for the November 12th pretrial.
Yes, sir.
Thank you, Your Honor, and I believe that's all I have.
Thanks, Mr. Garrett.
Have a good day, Your Honor.
You too. Mr. Cotton?
Good morning, Your Honor.
Good morning, sir.
We're going to have 2 cases on this morning's docket. The first is William Vance Valencia, 24 CF 1023. I have a written plea on that, if I may approach.
Yes, sir. Thank you.
Your Honor, that's a written plea to a misdemeanor. It has a place for the court to execute the order on the last page.
Thank you. Yes, sir.
Your Honor, the next case I have is Harrison Schuler. Mr. Schuler is present in the courtroom. Come on, please. Your Honor, after meeting with the state, we are attempting to resolve this case. We have not done so yet. I have a motion to suppress. I'm going to file. We need a new court date. If we could just push it to the next pretrial conference, I should be able to have that filed prior to next pretrial to get a court date.
Okay, so this case is not going to be moved to misdemeanor court.
Well, not at this time, I think.
Okay. Mr. Schuler, I'll see you back here no later than November 12th. But if Mr. Cotton sets that motion hearing, I'll see you then.
Thank you, Your Honor.
Thank you for dressing up for court.
Thanks, sir.
Yes, sir. Thank you.
Your Honor, that's all I have.
Can I ask one thing before, so for Mr. Valencia, is it, he's pleading to 2 counts of POP?
No, it's 1 count of POP.
Okay,
Count 1
I
was
see.
dismissed.
Okay.
It should say that on the,
Yeah, I
you see it? Okay, perfect. That's all I've got, Judge.
Thank you, sir.
Thank you, Your Honor.
Yes, sir. Mr. Kleins?
Oh, I was going to talk.
Oh, okay. Let's see if I have any pro se's. Yes. Mr. Tran? Doug Swan Tran, Mr. Tran? And it's 16 CF 40? Hello, Mr. Tran.
Hello, Your Honor.
Does the state have an offer for Mr. Tran? It says number 50.
I've paid off probation completely in 4 months. I paid off $3,800. I paid off all the court fees.
It was continued so that he could complete the original requirements.
Okay.
And if I can just verify that that's been done, then that would
Okay.
be great.
Probation at 16 CF 40.
I'm sorry for being here.
No, good job. Hopefully they're going to have all that in the system and they can verify that. You did good.
I don't have the clerk open right now. Just
Ms. Niles, I'll take your case next, okay?
When I was 18, I never committed those crimes. I'm sorry, guys.
the court fees are paid off. What else was he supposed to do? Sorry.
Complete.
Was it just court fee? What else was he supposed to do?
He just had money to pay.
$3,800 to state probation. Officer Brony to profit is my probation officer. I verified with him yesterday. Are we able to call the officer last time?
Probation, do you want to pass Mr. Tran for a few minutes and then bring him back? Okay,
This
good.
time, Your Honor, the state would ask the court to dismiss the violation of probation and revoke and terminate his probation.
Good. Mr. Tran, your supervision, your probation is terminated, and the violation of probation is terminated. Mr. Tran, Mr. Tran, I echo the state's, he said to you earlier when you said, "I'm sorry," and he looked at you and said, "No, good job." Good job, sir. A lot of people don't make it through probation. Your case has been pending since 2016, and so now it's over, sir. So walk out of the courthouse without us looking over your shoulder.
I'm so sorry for everything I've done, y'all. I don't know the universe, God, pitch perfect. Thank you so much.
Yes, sir. Have a great life, sir. Thank you.
Thank you, Your Honor. Thank you, Mr. God.
Most welcome. Take care, man.
Hello, Ms. Niles.
Good morning, Your Honor.
Morning, ma'am.
Laurel Niles from the Michael Efferman Law Firm on behalf of Raphael Stoffel. This is case number 2014 CF 1876.
Yes, ma'am.
So, Your Honor, we have an outstanding post-conviction motion that is pending, but we do believe we're going to be able to resolve it without a contested evidentiary hearing. We just have not been able yet to schedule an in-person meeting with the state to discuss the details of what that might look like. Our office has been emailing and calling Ms. Bossow for the past couple of, I believe the last couple of months, including last week. And we just haven't been able to schedule that yet. So we're hopeful to be able to get that done soon. And we would ask if we could please continue for another status conference in approximately 60 days, with the understanding, Judge, of course, that we will advise the court if we have reached a resolution sooner and get that on the court's calendar.
Okay, to the state, do you know what's going on with Ms. Basso in this case?
Judge, I know she's had several cases set for trial. That's where she was Monday. I did speak with Ms. Basso as far as the status of this case. Perhaps we could set it for 60 days out. as a contested hearing, and then if we can bring it in for resolution before then, let the court know, just so we have something solid on the resolution either way.
Okay, any objection to that, Ms. Niles?
I think I would object to that at this point because the contested hearing is going to involve, witnesses and we'd need more than 60 days to get that in place. We can do another status in 30 if that
let's do that.
helps a little bit. Okay.
Okay, so status conference on October 21st at 9 o'clock. And you mentioned that you had a motion that you were going to file, so if we don't get it resolved on October 21st, then I'd want that motion, okay? Not that date, but we'll need to set it that day.
Understood, Your Honor.
Okay. So I'll see you on October 21st at 9.
Thank you.
Thank you, ma'am. Any other counsel on? Okay, I don't see.
Judge, if we can recall Sheena Russell, I think it was handled earlier, but Paul Gillespie for the state.
Okay, yes, sir.
Judge, Tim Shaw for Sheena Russell, Judge, this is a case we called earlier, as I was going out the front door, Mr. Gillespie was coming in, so we came on back up.
Okay,
I just want to, Judge, it's set for a status hearing. It's been an older case, and I'd like to get it moving in a direction to resolution, either a trial or a plea. Talking with Mr. Shaw, there may be some additional discovery from his end. I know we've sent out some more. I don't know if there's another status date, or I think right now it's set for November
12th.
12th. What are the trial dates for that?
November 25th, it's a 3-day work week, and December 2nd.
Okay. I may need to look, the reason I'm very eager to get this resolved in some fashion is I've got about 5 other cases that are all coming to a head come November, and we may need to get some sort of scheduling order to make sure we get everything discovery-wise and everything set for a possible trial.
I think maybe I just overheard the court on another case, there was a status date in October.
Oh, we've got plenty of status days.
If we can set something in October, perhaps to see where we're at.
Okay, do you want it a month out or less than a month?
I'd say a month.
A month would be good.
Okay, so we'll set it for a status on October 21st at 9 o'clock.
That's perfect.
October 21st, 9.
Thank you, Judge.
Good, thank you. Thanks for coming back, Mr. Shaw.
Hey, no problem.
Okay. Okay, thank you. Mr. Malnick is for who? I'm sorry.
Good morning, Your Honor. Ken Malnick on behalf of Mark Ward. My client is marking me to appear on the screen. We have a negotiated change of plea, Judge. This was negotiated. It's case number 2023 CF-2471 CF. Judge, if I'm a little not incoherent, but I became a grandfather late last night, so
Congratulations, sir.
for the first time, so I'm a little not rattled, but just maybe not myself.
We'll start
So-
with Mr. Malnick. All we can see is the very top of your head.
Okay, I'll stand up if that helps.
Yeah, or you can just turn your camera down. Either.
I don't know. I'm not the most computer savvy. I don't mind standing. So it's a drug possession, controlled substance without prescription. It's going to be a change of charge to a misdemeanor possession of paraphernalia, and Mr. Snell was kind enough to offer a withhold adjudication and court costs. My client is willing to plead no contest to that, and I was under the impression that for a misdemeanor, we didn't need any paperwork, but I did go through what I anticipated would be a plea colloquy with, so I turned Mr. Ward over to the court, basically.
Okay, Mr. Ward, if you'll raise your right, first off, take your mic off mute.
Unmute.
Perfect.
Okay, there we go. Good
Raise your
morning.
right hand. Your other right hand, there you go. Do you
Yes.
swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Yes, sir, if you can put your hand down. Mr. Ward, do you understand that if I accept your plea that you're waiving your right to a trial by jury?
Yes, Your Honor.
Okay. And that adjudication would be withheld, you just need to pay the court costs, and I'd ask you how long you'd need to pay those. Do you understand that?
Yes, Your Honor.
Do you have any questions for me or your attorney or the state?
No, Your Honor.
Okay. Mr. Ward, I do accept your plea. Adjudication is withheld to the misdemeanor. You'll need to pay the court costs. How long will you need to pay? It's about $300.
Can we, is there a way maybe we can do 30 days? I can have it paid in full within 30 days?
Yes, sir, you've got it. If you fail to pay it within 30 days, then it will go to a civil lien or judgment. Okay.
Okay.
Thank you, Mr. Ward.
Thank you, Your Honor.
Mr. Malik, you look like a grandfather.
I feel like a grandfather, Judge. I'm 66. So it's a great thing. My mother just turned 90 a week ago. Very blessed.
Yes,
Thank
sir.
you so much,
Very
Judge,
much.
and thank you, Mr. Snell. And go Auburn.
There you go. They need it. They need an offensive line.
And a defense.
Thank y'all.
Thank you.
Okay. To public defender, if you want to call the folks in the gallery or the inmates that the folks in the gallery are waiting for.
Morning,
Yes, sir.
Judge.
Good morning, Mr. Crowd.
If I may call Mr. Christopher Stagner, who's present and approaching, and this is case number 24 CF 1935.
Yes, sir.
Judge, this will be a change of plea this morning, no contest. Count 1 is going to be the lesser included, sell, manufacture, deliver, or possess with the intent to sell a controlled substance. That's Florida Statute 893.13, subsection 1, subsection A. My client will be adjudicated guilty, 3 years of standard probation. There's a $40 cost per month of supervision, $615 in court cost, $150 in defense cost. No alcohol, no drugs without a valid prescription, the random urinalysis, random breath test, 24 hours community service, the substance abuse evaluation, and any recommended treatment. Must maintain gainful employment or 5 job applications per week. Your Honor, my client has never been adjudicated guilty on a felony before, so this will make him a convicted felon, and we did have that discussion. If I may approach the signed plea form?
Yes, sir. Thank you. Thank you, sir. Mr. Stagner, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Stagner, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, I did.
So, Mr. Stagner, even though this is the lesser included offense, it's still a felony. Do you understand that if I accept your plea, that you'll be a convicted felon?
Yes, sir.
Do you still wish to enter the plea?
It's better than going to jail.
Mr. Stagner, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation. You'll need to pay the $40 per month cost of supervision, the court cost, $150 public defender's fee, have no alcohol or drugs without a valid prescription, submit to a random urinalysis, random breath test, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. You'll also need to gain gainful employment or obtain gainful employment. If you don't have gainful employment, then you'll need to do five job applications per week.
Yes, sir.
Mr. Stagner, good luck to you, sir.
You too.
Thank you, sir.
Your Honor, that's all I have, President.
Okay. Mr. Kleins, anyone in the gallery?
Your Honor, first I have is David Mayo. Mr. Mayo was making his way to the podium, Your Honor. We did get the pretrial intervention agreement executed. So I guess the court needs to put this on for status, just to make sure the paperwork went through.
Okay. Hello, Mr. Mayo. Good morning. I'm glad that they've offered and you've accepted the pretrial intervention agreement. just where all the paperwork is finished, where it totally doesn't fall off my radar, I'm just going to continue your case until November 12th. But if all the paperwork's completed, you don't have to show up then. So stay in touch with Mr. Kleins.
Yes, sir, Your Honor.
Thank you, sir.
All right. Good luck. Next, I have Roger McGowan.
Hello, Mr. McGowan. Mr. McGowan, I'm glad you're here.
Your Honor, this is Mr. McGowan, 24 CF 1073. He has reached an agreement with the state to resolve this case. At this time, Mr. McGowan is going to enter a no contest plea as charged. The agreed upon disposition on count 1 is that he'll be placed on 18 months of probation. Count 2, credit for time served. A condition of that probation is that Mr. McGowan will complete 24 hours of community service. There will be $610 in court costs, $150 in public defender fees. This agreement, or probation, I'm sorry, would automatically terminate at 9 months if all of the conditions and court costs have been paid. There would be a withhold of adjudication.
Okay, good.
May I approach?
Yes, sir. Mr. McGowan, the reason why I said I'm glad you're here is because I had a note that said you weren't here before.
Yeah, no, I'm aware. I'm sorry about that, Your Honor.
Mr. McGowan, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. McGowan, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Very much so.
Good. Did you sign the plea agreement?
I did.
Mr. McGowan, I do accept your plea. Adjudication is withheld. You're sentenced to 18 months probation in count 1, time served in count 2. You'll need to perform 24 hours of community service work. Pay the court costs, $150 public defender's fee, $40 per month cost of supervision. Your supervision will automatically terminate at the 9-month mark if you've completed all the terms of your supervision and haven't committed any new law violations. Thank you, Mr. McGowan. Good luck to you, sir.
Next, I have Samuel Mock.
Hello, Mr. Mock.
Your Honor, at this time, the state is going to be announcing a dismissal of this case.
Mr. Mock, your case number 23 CF 2866 is dismissed. Thank you, sir.
Thank you. Last I have in gallery, Your Honor, is Mariah Mott. May I approach with the score sheet on Mr. McGowan?
Yes, sir. Thank you. Thank you, sir.
Your Honor, this is Ms. Mott. I spoke with her in the hall. I believe she's going to request a Nelson hearing.
Okay, if you'll hold on 1 second.
Sure.
Okay, so, Ms. Mott, you're asking, first off, let me put you under oath. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, thank you. So, Ms. Mott, you're seeking for the court to find that Mr. Kleins has rendered ineffective assistance of counsel. Is that accurate?
Yes, Your Honor.
Okay, so you need to tell me what facts you believe fulfill that, excuse me 1 second. You need to tell me what facts you believe fulfill that requirement. Okay, so tell me how you believe Mr. Kleins has not performed adequately.
At the beginning of the case, he told me that the entire case was dropped, and it was just the process of getting there. I have multiple witnesses that heard him tell me that as well. And then I wrote a motion though last night. I was going to file it today, explaining everything in detail.
Okay, do you have that with you?
Yes, it's in my phone.
Okay, if you want to read it, you can.
I've never done this before, so I don't know if I'm doing it correct. Do I just read the entire thing?
Yes, ma'am. Tell me whatever you want me to know. This is the time for me to make the decision, so you need to give me all the information you want me to know.
Defendant Mariah M hereby respectfully moves this court to...
Mr. Collins, do you mind moving that mic closer to Ms. Mott? Thank you. Thank you, ma'am.
Defendant Mariah M hereby respectfully moves the court to conduct a Nelson hearing to determine whether her current attorney, Scott Kleins, has provided an effective and incompetent legal representation pursuant to Nelson v. State 274 SO,
Yes, ma'am.
2D 256, Florida. Is that, I'm sorry.
Yes, ma'am.
For the DCA 1973, and in support thereof states the following. One, attorney representation and miscommunication. Mr. Scott Kleins, the attorney of record, has continuously miscommunicated and misrepresented the status of my case. On multiple occasions for over a year, Mr. Kleins has informed me that my case was dropped due to credibility issues surrounding Officer Simpkins, the arresting officer. 2, unreliable witness. Mr. Kleins repeatedly informed me that Officer Simpkins, who arrested me, had a history of misconduct, including pulling people out of the vehicle, claiming them to be fidgeting, and had been caught lying in a previous case. I was led to believe my case was being dismissed based on Simpkins being deemed an unreliable witness. 3, long process and continuances. For over a year, Mr. Kleins repeatedly advised me that the dismissal of my case was in process, requiring only time for completion. Throughout this period, Mr. Kleins sought continuances on my behalf without my direct appearance in court on the bias that the case was being dropped. Multiple witnesses, including Haley Glass, Heather Unbier, Hannah Mott, Lisa Evans, as well as Chad Evans, were present during some of the phone calls between Mr. Kleins and myself, and overheard Mr. Kleins telling me that my case had been dropped. 4, contracted statements. Mr. Kleins now has denied ever telling me that my case was dismissed, contradicting his previous statements on look-in. Additionally, when I questioned Mr. Kleins about the previous case involving Officer Simpkins, he claimed not to recall the case despite having previously informed me of it. 5, discouragement from seeking private counsel. When I expressed interest in retaining private counsel, Mr. Kleins discouraged me, asserting that it would not be in my best interest and that no other attorney could provide better representation despite my doubts. I reluctantly relied on his advice, feeling pressured to continue with his representation. 6, motion to suppress and denied reconsideration. When my motion to suppress was denied by you, Mr. Kleins informed me that he believed we should have prevailed in that motion hearing. He briefly mentioned requesting Judge Brown to reconsider the ruling, but immediately discouraged pursuing the motion for reconsideration, stating it would be a waste of time and not in my best interest. 7, pursue to accept plea deal on September 15th, 2014, when I was requested a continuance for the first time. Mr. Kleins told me that I would need to personally explain to the judge why I was seeking a continuance. This made me feel as if I now was representing myself. Moreover, after overhearing a conversation with my mother on the phone about seeking private counsel, Mr. Kleins pressured me to accept a lesser sentence and only gave me 2 days to make a decision before removing the offer off the table. Sorry. Mr. Kleins has created an atmosphere of fear and coercion. Mr. Kleins has created an atmosphere of fear and making me feel pressured to accept a plea deal out of fear and consequences if I do not sign it, rather than acting in my best interests. Wherefore, defendant respectively requests that the Honorable Court conduct a Nelson hearing to determine whether Mr. Kleins has provided an effective assistance of counsel to permit defendant to retain private counsel, and the court finds that Mr. Kleins represented has been inadequate or ineffective, inadequate or effective. Respectfully submitted, Mariah M. defendant.
Okay. Thank you, ma'am. Anything else factually you want me to know? Is that a no?
No, Your Honor.
Okay. Thank you, ma'am. Mr. Kleins, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Mr. Kleins, how do you respond to that?
Your Honor, never once in my career have I guaranteed a specific outcome to a case. Never one time. This has never happened. There are times when I will guarantee a client that a case will resolve at some point in the future, some way, somehow. How that happens or when or why it happens the way it does, I still don't guarantee. I did tell Ms. Mott that I thought that the motion should be granted. I would point the court to two specific things that she said there. Number one, she said, I told her that the case was going to be dismissed because of witness credibility issues. I don't know a single trial attorney in this country that would say that. I mean, especially in the state of Florida, because I know the jury instructions, and the jury instructions assess credibility issues to the jury. I would not tell anyone that a case is going to be dismissed because somebody's not credible. That's not a decision for me to make. And there's no way I can accurately predict if somebody's going to be found credible or not. So I would never say that, and I have never told Ms. Mott that the case was going to be dismissed because of witness credibility issues. She also told the court that I cannot now remember the name of the other case. That is factually inaccurate. I know exactly what case she's talking about. So the fact of the matter is that Ms. Mott has known for 11 months that this motion was denied. It was denied last October. She has had 2+ years to seek adequate counsel. She wants to hire a private attorney. I don't know a public defender in this country that would discourage somebody from taking a case off of their docket. I would love for every one of my clients to go hire private attorneys. I would never discourage somebody from doing it. I may have told Ms. Mott that I think it would be a waste of money given the facts of the case, but certainly this applies to any client that I have in the courtroom. If you want to hire a private attorney, please do. So I think that Ms. Mott is just upset that the situation has come down to what it is. I did secure an offer of 3 years, which frankly is gracious considering the facts of the case. The FDLE report in this case shows that Ms. Mott was in possession of 3 ounces of crystal methamphetamine in the neighborhood of 80 grams, allegedly. If she wants to go to trial, that's fine. She's going to be risking a 7-year minimum mandatory sentence, and it's a first-degree felony, could be punishable by up to 30 years. If she wants to proceed to trial, I'm all for it. I'd never guarantee her an outcome in this case.
Okay. Ms. Mott, anything else you want me to know?
I just know I thought I was going crazy, but I have multiple witnesses that have heard him tell me that the case was dropped.
Okay. And so you believe that Mr. Kleins has told you that the case was actually dismissed and gone?
He told me it was just the process of getting there at the beginning of our case because I kept getting continuance, and he was wavering my appearance at first. And he was just every single time I would talk to him on the phone, he would just tell me it was another continuance, he was wavering my appearance, and the case was dropped. It was just the process of getting there.
Well, but your case was filed in 22, and the motion was heard 11 months ago? Is that accurate?
But I asked him, when he told me that there was a possibility of being able to ask you for a reconsideration, he told me there was no point in asking for you because you don't ever reconsider anything.
Well, it'd have to have something new or, some new authority or something. It couldn't be the same argument again because I'd come up with the same conclusion. The time periods don't work in your favor as far as how long the case has been open, how long ago the motion to suppress was ruled on. So respectfully, your motion for the court to find ineffective assistance of counsel. Before I say the last word on that, to the state, did the state withdraw the 3-year probationary offer to Ms. Blunt?
We did not offer 3 years of probation.
Okay.
Want to make sure that's clear.
So you've never offered that?
We offered 3 years in the Department of Corrections. This was a particularly straightforward set of facts for the state.
Okay, hold on. I just need to know because Ms. Mott said that the prior offer from the state, she felt that Mr. Kleins had put pressure on her, and then basically it wasn't accepted in just a very few days, and so that made me think that the offer was withdrawn.
The offer was open until today. We said if she wants to go forward with trial, then we would remove the 3-year minimum mandatory offer, and we would proceed to trial on the 7-year min-man.
Okay, so the offer is 3 years mandatory minimum in prison, right?
That's correct, Your Honor.
And then the things that we did, talk about the balance of what that is, if Ms. Mott had any interest in accepting that.
That's correct.
Okay. Ms. Mott, do you understand that offer is still outstanding, that's still there?
And it's not up to Mr. Kleins whether or not it's open or not. I just want to make sure that that's clear for Ms. Mott. It's up to the state. I was the one revoking that offer.
Ms. Mott, that was the final piece of the puzzle for the court. I find that Mr. Kleins has not rendered ineffective assistance of counsel, so your motion is respectfully denied. So, Mr. Kleins, aren't we scheduled to go to trial?
We are, Your Honor. I believe the court is scheduled 2 weeks from tomorrow, basically. We never did that.
I believe it was the second Friday, September 5th. Is it 4th?
Yes, sir.
4th. Oh, I'm sorry, yeah, October 4th.
No, it's the first Friday.
I asked my legal assistant to reach out to the 2 witnesses that we would be calling, and I'm still trying to verify that that date would be okay, but I'll let the court know if that changes.
Okay, and how many do you want on the venire?
35.
I was going to propose 22, but
Yeah, it's not a lot. 30 is good, Judge.
Okay, so 30. So then, please give me jury instructions over the next week or so. Ms. Mott, I will see you back here at 8:30 on October 4th. That's a Friday. We'll start selecting the jury and then start the jury trial. So I'll
I'm not
see.
allowed to hire private counsel for a trial.
You can certainly hire a private attorney. And if that private attorney files any kind of motion, we'll set it for a hearing and I'll hear that motion. Okay? As Mr. Klein stated, you certainly have the right to hire counsel of your choosing. It being this late and right before trial, I can't tell you that I'll continue the trial, but again, I don't have any motion before me. So, if you hire a private attorney, I'll rule on any motion that I've got. Okay?
Yes, Your Honor.
Thank you, ma'am. Okay, I've got an empty defense table. Mr. Klein, do you have anybody else?
Not on the morning docket, Your Honor.
Okay. If you want to grab another attorney, that'd be nice. Mr. Dees, you want to do your case?
I would, Your Honor. Thanks for allowing me to appear by Zoom.
Yes, sir.
I'm between Pensacola and Fort Walton, but my understanding is I have Armando Rosales, who I do not expect to appear before the court today.
Okay.
I'd ask the court to maybe sound the courtroom for him one time, but my understanding is his intent was not to appear.
Armando Rosales? Is Mr. Rosales present? No, sir, he's not here.
Yes, sir, Judge, he's already got a previous order out revoking his bond for tampering with the GPS monitor, so I think this is all going to be one issue, so I just asked the court to enter failure to appear, issue a KPS.
Okay, and I did have plea or trial. So
Yes, sir.
Mr. Rosales was ordered to be here. He's not present. A KPS will be issued for Mr. Rosales, and it'll be a no bond KPS.
Perfect. Thank you, Judge.
Thank you, Mr. Dees.
Very efficient. Thank you. You guys have a good day.
You too.
All right, thanks.
Yes, sir. Mr. McKinney?
I have Carlos Valdivia before the court today, is 24 CF 1317.
Morning, sir.
Good morning, Your Honor.
He is standing with me at the podium, 24 CF 1317. We've reached an agreement with the state. The agreement calls for a plea as charged, adjudication of guilt, 6 months of community control, followed by 12 months of standard probation. Special conditions include GPS monitoring, and I included the language is set at a minimum rate for the court or probation to decide. Register is required, $515 report cost, $150 cost of defense. There would be a $40 a month cost of supervision.
In the adjudication?
He would be adjudicated guilty, and he's previously been adjudicated.
Okay.
Judge, this is a negotiated downward departure. No objections to the score sheet, which reflects 59.6 points. May I approach?
Yes, sir. Thank you. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir.
They would attach the GPS at probation, is my understanding.
Okay, thank you. Okay, and you, in the plea agreement, you wrote the same thing you said verbally. You just said, register as required.
Yes.
Expound on that to make sure that your client
Judge,
knows.
to register, he has registration requirements outside the plea agreement.
Register, oh, okay, that are not,
The registration requirements relate to, this is a failure to register case. He must comply with all the registration requirements related to his designation. We've had that discussion many, many times.
so he was previously designated
Correct.
Okay.
Correct. This is a failure to register case.
as a sexual offender.
Correct.
Good. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months community control, followed by 12 months of probation. You will need to wear a GPS monitor, follow and fulfill the registration requirements, pay the court costs, $40 per month, cost of supervision, $150 public defender's fee. See if I can turn down my mic a little bit. And you'll pay for the GPS monitor at $1 per day or the lowest amount allowed. Thank you, sir. Good luck to you.
Thank you, Your Honor.
Judge, I also have Mr. Bill Watson in the courtroom. Mr. Watson is approaching in 22 CF 1064. Mr. Snell is the assistant state attorney in this case. There was some discussion on whether or not it was or it wasn't on the trial docket. I believe it's not on the trial docket based on the unavailability of witnesses.
This is William Watson?
This is William Watson, yes,
Okay.
22 CF 1061.
Well, my notes say plea trial, but then I had a note that said no trial.
Correct, and the discussion, to remind the court, when the court inquired of the defense of the state at docket day, whether or not we'd be ready for trial, there was witness unavailability on the state side, so we basically said, let's leave it on for status to see if we can get it worked out.
Okay.
I did meet with Mr. Snell yesterday. We are still, to bring the court into the discussion, and I'm not asking the court to make any decisions, but so the court knows what's going on. We're trying to establish a firm restitution amount, which is the controlling part of this case. So I believe, absent a plea agreement that we can enter today without that number in place, we would just ask for a joint continuance until November 12th, understanding that this is something that needs to be resolved on the next cycle, if not sooner.
Mr. Snell?
I agree. I'm hopeful. I believe that we'll have a firm number. We just got to work it out over the next few weeks. So.
Okay. So, Mr. Watson, I'll see you back here no later than November 12th at 9 o'clock. If it's not resolved, then the court's going to be pushing for it to go to trial, okay? Thank you, sir.
And the court has court dates through October that are miscellaneous dates.
Absolutely.
We may try to land on one of those. I'm not asking for that to be scheduled today. But as we move forward in trying to resolve this matter, I don't want to lose that traction.
Mr. Watson, if you want to avoid about 200 or 300 people, if the state offers you something that you want to accept,
Yes, sir.
Mr. McKinney can set it for a hearing.
No problem, sir. Thank you.
Thank you, sir.
Have a good day. Thank you.
You too.
Yes, sir. Judge, I also have Ms. Brenda Watson. Ms. Watson is before the court in violation of probation in 23 CF 2824.
Hello, Ms. Watson.
Hello, how are you?
Good, how are you?
I'm better.
Good.
We've reached an agreement related to violation of probation. Ms. Watson is going to admit to the violation of probation. The state's going to keep the withhold adjudication. We're going to reinstate the probation to complete the original conditions. There's a $100 VOP fee and $150 cost of supervision. May I approach that plea agreement?
Yes, sir. Ms. Watson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Watson, did you read the plea agreement?
I did.
Do you understand it?
I did.
Did you sign it? Yes. Ms. Watson, I do accept your plea. Adjudication is withheld. Your current supervision is reinstated with the original terms and conditions. You'll need to pay the $100 cost of prosecution and a $150 public defender's fee. Thank you, ma'am. Good luck to you.
Thank you.
Yes,
You have a
ma'am.
blessed day.
Thank you, ma'am. You too.
We're gonna do Allison Snipes first.
Okay, thank you.
Good morning, Judge.
Good morning again, Mr.
Snipes. We're on two cases, 23 CF 1824, 24 CF 1346, Your Honor. In session of the leader continuance. Ms. Snipes, and Your Honor, we've been on a counter back and forth for a little bit for 100 days, jail time, revoke and terminate. I spoke with the state attorney this morning, and I got a new offer, so I want to share it with you, Ms. Snipes, because it is time sensitive. Like I said, I just heard it this morning. They rejected our 100 days offer, revoke and term. They countered with 1129, or if it's not accepted today, the offer goes up to 15.45 months Department of Corrections, which is the guidelines. So just to reiterate, our counter, they shot down. It's an 1129 offer this morning, that's time sensitive. If not, I was informed guideline sentence of 15.45 months. And I know that's a lot, Ms. Snipes, but I was informed this morning and I wanted to share that with you.
Okay. Ms. Snipes, the court can't make the state offer you anything no more than I can make you accept something. So, I understand what Mr. Koch just stated, that the state can offer or withdraw any offer anytime they want to. You don't have to accept anything. If you don't find it in your best interest, it's up to you. If you say, I don't want to do that, you don't want to accept the offer, then I'll see you on November 12th, and I'll be looking at going to trial at the end of November.
For the VOP or for the possession charge?
The state has the right to decide which one they want to pursue first. To the state, which case would you want to pursue first? Miss Snipes.
I would move to
For the-
a VOP hearing first.
Okay. So, Ms. Snipes, we have basically a judge trial for me to determine if the violation of probation, whether you did that or not.
So if I was to accept the 1129 right now, I get time served for all of the time that I've done since August of last year?
Mr. Snell?
She would on the VOP, yes.
Okay,
She
what about
wouldn't have
the-
that credit for the new law violation.
Okay. How much when would the time start for the new law violation? The credit time?
Looks like our arrest date was 6/11 of '24.
Okay. So, Ms. Snipes, it sounds like that you would only get credit from 6/11 to today against the 11/29.
So I would only get, so I would have to do 11/29 starting on,
6/11.
no, thank you.
Okay. So does the
For
state want?
possession, for the possession charge? Get 11/29 for that? I'm asking.
I'm not the one, that's what the state is offering. Yes, ma'am, is 11/29 for both of your cases?
They can't run them together, please?
They would, the time would run concurrently, but you wouldn't be given credit for the new law violation back to before you ever were arrested on it, no.
So it would be like 11/29 twice?
No,
Is that what it,
no,
I'm not
no,
understanding.
ma'am. It would be 11/20, for practical purposes, it would be 11/29 starting on 6/11/24. That would be when you'd start getting credit. The other case would be resolved quicker because you have more credit for time served on that, it sounds like. But as far as how long will you be in jail, under the state's offer, 11/29 from June 11th of this year. Correct, Mr. Snow?
Yes, sir.
Okay.
Ms. Snipes, face the judge, please.
And the other thing that Mr. Snell stated is that the score sheet shows, what, 15 point something months?
4 or 5.
Okay, and that's in prison. Has Mr. Koch told you what the court has to find to go below that amount if the jury finds you guilty?
We have not discussed any plea to bench.
No, I'm not talking about the bench. If, just as far as to go below the score sheet, the downward departures?
Negative, Judge.
Okay. Do you want to pass Ms. Snipes until later this morning and you talk to her about that?
If I could, Judge, I would, yes, please, just because the time-sensitive offer this morning, it was changed, absolutely.
Right. Ms. Snipes, so talk to Mr. Koch. I want you to know, when I was a mediator, I used to think I had to get everybody to agree on something. And after doing that for 6 months or so, I decided, nope, my job isn't that. My job is to get you as much information about your case as I can, and then you make a decision about whether it's in your best interest to settle it or not. Here, I feel like my job is make sure that you know everything about your case that you can, and then you decide whether you want to accept the state's offer or not, or whether we go to trial. The only thing I can make you and the state do is go to trial. So Mr. Koch will come back. Yes, sir.
One moment.
Certainly.
I understand, I wouldn't get out of jail
Ms. Snipes, I'll see you later this morning.
Yes, sir.
Take that, please.
Can I, whenever we talk, can I talk with my mom?
This one,
Security won't let you do that here. Okay.
Anthony, talk to me this night.
Thank you.
Come on this way, and please stop talking to her. I'm not gonna tell you what you're doing. Get out. She's not done.
Judge, Mr. Antoine Parson. We got 3 cases, the 23 CF 2766, 23 CF 1629, 23 CF 1952, Judge.
Yes, sir.
Judge, this was set clear continuance. I'm seeking a continuance trial next time. Unfortunately, our counters were rejected, and we're currently at a guideline sentence of 44.1 months. Just to inform the court and the state, in the meantime, from our next pretrial, I am going to have my client just evaluated just for potential future bench. So I just want to confirm and assure the court, next time will be trial or a plea. And of course, if we get a counter sooner, this will be resolved.
Okay. Mr. Parson, I'll see you no later than November 12th. If the state offers you something that you want to accept before that date, I'll see you sooner, okay?
All right, God bless y'all.
Thank you, sir. God bless you.
Mr. Parson.
Attorney Cornell, is there?
Yep, yes, sir. Judge, this is Mr. Quentin Cornell in 23 CF 2186.
Yes.
Judge, on docket day, we have a counter offer of basically a time served OCJ followed by a Phoenix house. My client has been accepted. That's still pending. I spoke with Mr. Gomez this morning. They just got to reach out to the victims to verify that we can get that offer. So I'm asking for a continuance. They just got to reach out. Your Honor, so we're seeking that continuance, but similar to my last client, if for some reason that counter falls short, we're going to be geared up. We're going to listen to the deposition and we'll be ready for trial if it comes to that.
Okay.
So we're going to continue it to 11/12, but when I hear back from the state's attorney, I'm going to set you, if we get that counter, the next available court date with this judge.
I do think this will be in October, Your Honor. I just need to actually run everything through with the victim.
Okay. So, Mr. Burnell, I'll see you no later than November 12th. But it sounds like if the victim doesn't object, then the state will agree to you entering Phoenix House and that probation. So that means I'll see you in the next couple of weeks, hopefully.
Yes, sir.
Thank you, sir.
Robert Riddle.
Hello, Mr. Riddle.
Judge, we're here in 21 CF 961, 24 CF 1798 for a bond motion this morning, Judge.
Yes, sir. And I did read through the motion. Also printed off both of the incidents reports and highlighted information in both of those, so I'm up to speed. Yes, sir.
I was seeking to get some sworn testimony from the client.
Okay. Mr. Riddle, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Thank you. Can you please state your full name for the record?
Robert Louis Riddle, Jr.
Mr. Riddle, if you are released, where will you reside at?
710 Powell Drive,
And what city is that located in?
Niceville, Florida.
At the 710 Powell Drive, who, is that an apartment, a house?
It's a house.
Okay, who lives at that house?
Me and my sister.
Your sister?
Yes.
What's your sister's name?
Mary Riddle.
Mary Riddle?
Yes. The house is my mom's.
So, you said that's your mom's house also?
Yes.
Does your mom reside at that residence?
No.
Okay, what's your mother's name?
Eunice Mims.
And does she live in Okaloosa County?
No.
Where does she live at?
She's in Georgia.
Okay. Do you have any other siblings that live in Okaloosa County?
Yes.
Who are they?
Michaela Smith.
Who is that?
That's my sister.
And both your sisters, how old are they?
31 and 34.
Okay. And how long have they lived in Okaloosa County, Florida?
10 years.
How long have you lived in Okaloosa County, Florida?
14?
Around 14 years?
About 10.
10, okay. Do you have any medical conditions that you want to make this court aware of?
Yes, I do. I have sickle cell.
Okay. Are you under treatment for sickle cell?
Just the hydroxyurea.
What can you explain to the court what do you do for treatment?
There's really no treatment. I just go to the hospital.
Okay, but inform the court how many times a week or a month?
It varies on whenever the crisis hits. It's random.
So you go to the hospital and then what do you do?
I get fluids and meds.
Intravenously?
Yes.
Okay. What hospital or what location do you seek treatment in Okaloosa County?
White Wilson and Niceville. And the hospital it depends from Twin Cities to Fort Walton Beach Medical.
Of course, we have prior conversations about your treatment. Is that treatment important to you, or are you getting treatment in the jail, or explain to this court the importance of that for you?
It's very hard to explain the sickle cell, but when it happens, it starts in one area and expands all throughout the body. So I go in, get fluids and meds, and they have to keep it on I say 30. It's either 30 minutes to an hour.
Okay. And just a couple more. If released, will you stay in contact with my office?
Yes.
And if this court orders any sort of pretrial release conditions, will you abide by them?
Yes.
And if this court orders you to show up for the next court appearance, will you be there?
Yes.
No further questions, Judge.
Thank you. Any questions from the state?
No, Your Honor.
Okay. Yes, sir, argument?
Yes, Your Honor. My client's held on $3,500 cash professional, obstructing justice, $3,500 cash professional, burglary with assault or battery, $3,500 cash professional, battery, second or subsequent offense. I'm requesting that those be converted to signature bonds, and then ultimately his probation violation be converted to a $9,500 signature bond. So in total, all his cases would be a $20,000 signature bond, is what I'm requesting from the court.
Okay, thank you. To the state?
Judge, this defendant qualifies as a violent felony offender of special concern under Florida Statute 94806.
He does qualify?
Yes, Judge. He was on probation for child neglect in 21 CF 961. He was sentenced to 36 months on that, and while he was on felony probation, he committed a qualifying offense, which would be the burglary of a dwelling with assault or battery, which is a first or second degree felony, which would make him a violent felony offender of special concern. And therefore, he's not entitled to a bond or bail.
Mr. Koch is finding out about that, Mr. Riddle, because if that is true, then the court has no discretion. I cannot legally give you a bond.
And you're right, Your Honor, I was just verifying, I believe, or it was my understanding that 21 CF case was originally put out to the lesser of felony battery. That's what I was confirming. But I was unaware of that status on my client, Judge.
I believe it was noted in the first appearance paperwork as well. I think the lesser included was he was charged with possession of cocaine and he pled to possession of paraphernalia. There was 2 felonies. He pled to a misdemeanor in 1, I believe, but I will double check.
Those 2 different cases.
Just, I don't want you to make any statements. Let me just verify that paperwork. Judge, if I just have a brief moment.
Yes, sir.
Just want to. Okay.
And the plea agreement on February 14th, 2022 reflects he pled to 36 months of probation to 1 count of child neglect in 21 CF 961.
So, Your Honor, no, and thank you, Mr. Rickman, for pointing that out. My client is a violent felony special concern, notating that paperwork in his file, and as you stated, Judge, that would not entitle my client to any bond on that probation violation. So knowing that now, I will withdraw that bond motion. This will be, I believe we're still set on the 11-12 pretrial docket.
Yes, sir.
Depositions are being set, so if we can stay on that 11-12 docket, Your Honor.
Okay. Mr. Riddle, I'll see you no later than November 12th. Thank you.
All right, Mr. Riddle. I'll talk to you in jail, off the record.
I believe Mr. McKinney is going to address Anthony Youngblood.
Judge, I do have Anthony Youngblood in the courtroom. He's here in 2 cases, 23 CF 1736, 23 CF 2110. These are violations of probation. I believe in reviewing this, the state's going to dismiss the violations of probation.
This is Mr. Youngblood.
It is.
Your Honor, at this time, the state would ask the court to dismiss the violation of probation in 23 CF 1736 and 23 CF 2110. The basis of the violation was a new law violation that was ultimately dismissed by the state attorney's office. So based on that, we'd ask the VOP to be dismissed and then just reinstate his probation to complete the original requirements.
Okay. Mr. Youngblood, there's no downside to you for that. So the VOPs are dismissed and your current supervision is reinstated. Okay? Thank you, sir.
Mr. Clancy, I recall Mariah M.
Okay. Hello, Ms. Pott.
Your Honor, Ms. Mott is approaching. She is elected to accept the state's offer of the 3-year minimum mandatory in this situation. The specific terms, Your Honor, and we're going to ask that the court set off the sentencing to October 21st. And I have gone over with Ms. Mott the consequences of what may happen if she fails to appear or if she picks up new charges between now and then. It's actually written on the plea agreement, too. But at this time, Ms. Mott is going to enter a no contest plea on count 1 to the lesser included offense of trafficking methamphetamine 14 to 28 grams. The agreed upon disposition on that count will be that she will be sentenced to 36 months in the Department of Corrections with credit for all time served. Count 2 is a first degree misdemeanor. She will enter a no contest plea on that. The sentence on that will be time served. Ms. Mott is going to be adjudicated. She's never been adjudicated before. She has no prior record, but unfortunately, that's the reality of the situation. Importantly, Your Honor, Ms. Mott is going to reserve the right to appeal the motion to suppress ruling that this court has issued. I would request that the state certify that that is a dispositive motion.
It is dispositive, Your Honor.
Thank you.
I believe that's it, Your Honor.
Okay. Then there's court.
There's a $50,000 mandatory fine on this also, Your Honor.
And then there's court costs and a $150 public defender's fee.
That's correct, and I wrote on the plea form 967 court costs, Madam Clerk, is that correct?
It would just be the 515.
515?
Yeah, and then it would be the $50,000 fine plus the 5%, which is $2,500, and then the PD fees.
I'm gonna change the court costs on here, Your Honor, and have Ms. Mott initial that.
Okay.
The only thing that's being changed is 967 is being reduced to 615.
Okay. And then the $50,000 plus the 5%.
The $50,000 is already on there, so that's fine. The 5% surcharge is okay. I just didn't write it on the plea agreement.
Well, why don't you put that on there just to make sure?
How do I characterize that, Madam Clerk? What is it, 5% surcharge?
Yes.
Okay. May I approach?
Yes, sir.
And I'll have the score sheet with me, pending sentencing, I'll have it for the court at sentencing.
Ms. Mott, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can put your hand down. Ms. Mott, are you currently under the influence of any drugs, alcohol, or medication?
No. No, Your Honor.
Has anyone forced, threatened, or coerced you into entering the plea?
No, Your Honor.
Has anyone promised you anything other than what's in the written plea agreement?
No, Your Honor.
How far did you go in school?
11th grade.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Mott, do you understand that if I accept your plea that you're waiving your right to a trial by jury?
Yes, sir.
Do you, okay. Ms. Mott, any questions for the court or your attorney or the state?
No, Your Honor.
Ms. Mott, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel. I do find that there is a factual basis for the entering of the plea. once I say DOC, okay, then she's just got to, then I lose jurisdiction. Traditionally, we wouldn't have the sentencing until that day.
That's correct, Your Honor. This is the plea, and we're setting off the sentencing hearing.
Okay. So, Ms. Mott, I will see you on October 21st at 9 o'clock. If you fail to appear then you could be held in contempt of court. Also, then you could start over with the state. Well, let me stop there. What happens as far as the negotiated plea if Ms. Mott doesn't appear on October 21st?
It turns into a plea to the bench to you.
Okay. So, Ms. Mott, what that means is that you would basically be waiving your right to a trial by jury, and you'd go straight to sentencing without the agreement of the state. So you could be sentenced up to a total of 31 years in prison, as it states is at the top of the form. And then, did I hear earlier there would be a 5-year mandatory minimum? 7 years.
7.
Okay. So, Ms. Mott, do you understand that?
Yes, sir.
So I'll see you on October 21st at 9. Okay?
Yes, sir.
Just so the court's aware, Your Honor, we did discuss the hiring of appellate attorney. I did encourage Ms. Mott to reach out, probably to attorneys in Tallahassee. I would imagine there's a number of them, but she is going to be looking into hiring private counsel for the appeal between now and October 21st.
Okay.
Will the court
How
process go
long-
straight to judgment, or are you going to give her time to pay?
Ms. Mott would request a year from her release to pay those costs.
She's not sentenced.
Right, I just want.
Yes.
Okay. Thank you, ma'am.
Brendan Rogers is next, and Mr. Coffey.
Hello, Mr. Rogers.
How's it going, Your Honor?
Good, how are you?
Hanging in there.
Good.
Judge.
Yes, sir.
This is Mr. Rogers. We pushed it today for a plea or continuance so I can receive that offer and discuss with my client at the jail. We did receive that offer. It is 120 days, OCJ followed by 3 years probation, but they wanted adjudication of guilt. So at that time, my client must reject that offer and have a first-time continuance and be set on the 11-12 pretrial docket, Judge.
Okay. Mr. Rogers, I'll see you no later than November 12th. Okay? Thank you, sir.
And we'll be seeing you soon for that bond motion.
Okay.
Okay? This is from you?
Yes.
Ricky
Okay.
Shear is next.
Hello, Mr. Shear.
Good morning, Mr. Shear. Your Honor, similar situation. This was first time up on November 9th for pretrial. As we talk right now, I don't have an offer, but speaking with Mr. Snell, it's going to be a guideline offer once I get that score sheet. So I discussed with my client yesterday. I don't have the score sheet, so I can't tell you that number. I was informed that there's some history on that. So I'm requesting to put this on the 11-12 docket, Your Honor.
Okay. Mr. Shear, I'll see you no later than November 12th. Thank you, sir.
As soon as I get that offer, I'm going to come talk to you. Yep.
Benjamin Smith is next.
Thank you. Hello, Mr. Smith.
Good morning. Your Honor, we're here. My client has 2 cases, the 24 CF 1640. We're seeking a one-side continuance as the first time up and keep it paired with his 24 CF 111 case, Your Honor. We had some lengthy discussion yesterday, some motion suppression issues that we discussed, so that's why we're seeking continuance, Your Honor.
Okay. Mr. Smith, I'll see you no later than November 12th. But if Mr. Koch files a motion and sets that for a hearing, you'll come for that hearing. Thank you.
Jaheim Stanley next.
Thank you, sir.
The HE. Yes, sir.
Hello, Mr. Stanley.
Hey, how you doing?
Good, how are you?
I'm good. Just to clarify, you still want to move forward with this offer that we talked about? Okay. Completely. Correct. Thank you. That's your copy. This is the copy you give to the court. But that's the same. It's 992. Keep your copy. Thank you, Your Honor.
Yes, sir.
No follow-on, because we're going to enter the court. Your Honor, Mr. Stanley's going to enter a no contest plea this morning. It's going to be as charged. He'll be adjudicated guilty, the 100 days in the Okaloosa County Jail with credit for time served. There's 615 in court costs, 150 in defense costs. My client will be adjudicated guilty, and this will make him a convicted felon, Your Honor, and we did have that discussion.
Thank you.
If I may approach, please.
Yes, sir. Mr. Stanley, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Stanley, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Every single one.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Stanley, do you understand that if I accept your plea, that you will be a convicted felon?
Yes, sir.
Do you still wish to enter the plea?
Yeah.
This is on both counts, correct?
Yes, Judge.
Mr. Stanley, I do accept your plea. You're adjudicated guilty. You're sentenced to 100 days in the Okaloosa County Jail with credit for all time served, and that's to run concurrently, run at the same time between the two counts. You'll need to pay the court costs, $150 public defender's fee. How long do you want to pay those costs after you get out of jail?
About a month or two.
Is 3 months enough, or do you need longer?
Yeah,
Okay.
for sure.
So if you fail to pay those amounts within 3 months after you get out of jail, then they'll go to a civil lien or judgment.
All right.
Thank you, sir.
Yep.
Hello, Mr. Steen.
Okay, all right. Gotcha. Thank you.
Yes, sir.
Judge, we were set today, plea or continuance, but ultimately the key state witness has failed to show for 2 depositions, one back in February 26th, the other August 26th. Mr. Snell just needs more time to speak, I believe, with the supervisor's seat to ultimately drop this case. So I'm asking for a continuance, of course, put on the 11/12 date, but speaking with Mr. Snell, it sounds like they're going to make that decision within this week. My client is being held on no bond in this case. Mr. Snell also said that for some reason this case cannot get dropped, stipulation to a signature bond, so I just want to inform my client, once I get a okay if we're not dropping, but okay with the signature bond, I'll send a motion to your chambers, Your Honor.
Yes, sir.
Just to clarify that, I told him that we would sit down and work out and see if there's some kind of bond that we could agree on. But it's basically a conference, the two of us will get it. So there's no agreement as to a bond at this point, so.
Okay. Mr. Steen, if I was you listening to what I just heard, I'd be feeling like you have no control at all. You do, because Mr. Koch can file a a motion for an order to show cause. If he feels like that the state's not moving as fast as it needs to in your best interest, then Mr. Koch can do that. So the court's here to act. The court's passive in substance, so I don't just jump up and say, I'm going to do this. Parties need to ask the court to act. So Mr. Koch knows that. He probably also is biting his lip at this point because he may have some thoughts in the back of his mind that once he files that, he may lose some bargaining power with the state. I have no idea, but he knows that he has that power. So I'll see you back here no later than November 12th. Mr. Koch files a motion. I'll see you then. If you want to accept the state's offer, I'll see you then. If Mr. Koch files a stipulated motion for your bond to be reduced, I don't need to have a hearing for that. I can sign that without a hearing. So I'll see you in one of those events. Thank you, sir.
Thank you, Your Honor.
Parker Stewart.
Hello, Mr. Stewart.
Your Honor, this is Mr. Parker Stewart, 3 cases, 23 CF 2328, 24 CF 1576, 24 CF 1583. It was set today for a plea or continuance, Your Honor. The counter that we've been discussing, the 100 days, the plea form we reviewed, discussed, was not accepted this morning. And I was informed of a new offer with time sensitive, so if I may just put that on the record, Judge.
Yes, sir.
Our counter was rejected. The current offer today, time sensitive, is 11 months, 29 days in Okaloosa County Jail. And I was informed if we do not accept that, it goes to the guidelines score sheet of 17 months, .925. 17, about 18 months. And I was told this morning, I know that's a lot, that's why I wanted to share it on the record. Your Honor, if I could pass this up with Ms. Snipes, because just so he can review that and we can have a discussion further on this.
Right, and you're going to discuss with Mr. Stewart what the court would have to find to go below that score sheet.
Absolutely.
Good. Mr. Stewart, I'll see you later this morning.
Yes, sir.
Thank you.
Hold on to that.
Sherry Stone's next.
Thank you. Hello, Mr. Stone.
How you doing, sir?
Good, how are you, sir?
All right.
Your Honor, this is Mr. Stone. We're here for 6 cases, similar to my last client. Mr. Stone, I need you to both not pay attention, but the offer that we've discussed at length, the plea form we went over, that was rejected this morning. So, if I may, Your Honor, the current offer on the table is 36 months DOC, and I was told it was time sensitive. If not taken this morning, it goes to the guidelines of 49.8 months DOC. So, Your Honor, if I may pass up Mr. Stone this afternoon, I'm going to hand him the plea form and we can have some discussions about this new offer that I received.
Okay, so I'll see Mr. Stone this afternoon.
Yes, please.
Okay. Yes, sir.
Can I speak with you?
Yes, privately, yes. Thank you.
Justin Tipton with Mr. McKinney.
Okay, before we go, I know that you need to talk to a couple defendants, correct? Is that someone that's in the gallery? That, I mean,
They're here for a 130 client, Judge.
okay.
We'll try to
The
get them
arraignments?
this morning.
Okay. Since it's after 10:30, why don't we take a 10-minute break unless,
It's just 2
Okay.
with Mr. McKinney,
Then-
and then we're done with the 9 o'clock docket.
perfect. Yes, ma'am, let's do that.
You have Mr. Tipton. Mr.
Well, except for
Tipton,
Mr. Keach's client.
Got you.
That one I assume will take a little longer.
Okay, yes, sir.
Judge, I met and reviewed a score sheet with the state yesterday. I reviewed that with Mr. Tipton. I'd like to set this at 1:30 today, so I can discuss with him the state's offer in more detail. I have reviewed the score sheet, which reflects 42 months with Mr. Tipton, so I'd like to bring him back at 1:30.
Good. Mr. Tipton, I'll see you at 1:30. Thank you.
Alberto Torres Castillo.
Judge, this is Mr. Alberto Torres Castillo before the court in 3 case numbers. Each of these are violations of probation.
Good morning, sir.
Your Honor. Do you have any- We have an agreement, Judge, and I'm just executing that agreement at this time. The agreement on all 3 cases calls for an adjudication of guilt. He's previously been adjudicated 6 months in the Okaloosa County Jail concurrent between the cases. They will revoke and terminate his supervision. He will receive credit for all time served, and that includes time spent since April 20th of 2024, which is when he was arrested down in Naples.
And that's on all 3 of the cases?
Correct.
Okay. Then there'd be a $100 cost of prosecution times 3.
Yes, Judge.
And a total of 350 PDV.
Correct.
Okay.
And if I did not say, they would revoke and terminate his supervisions.
Yes, sir. Mr. Torres, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Torres, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Actually, he did a great job, Your Honor.
Good. Did you sign the plea agreement?
Yes, Your Honor.
Please. Yes, sir. Thank you, sir. I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months in the Okaloosa County Jail with credit for all time served, beginning no later than April 20th of this year, and that's to run concurrently, run at the same time on each case and count, again, with credit for all time served. Your prior supervision is revoked and terminated. You'll need to pay the $100 cost of prosecution for each of the 3 cases, total of $350 public defender's fee. Do you want a period of time to pay those financials after you get out of jail? How long will you need?
Judge, may we request 6 months?
Yes, sir.
Thank you, Your Honor.
Thank you, sir. Good luck to you.
Hey, thank you, Senator. Hey, really appreciate it.
Yes, sir. Let me grab you and give you a card. When you get out.
So, Mr. Keach?
Have a good day, Judge.
Thank you, sir. You too.
Good morning, Your Honor.
Good morning, sir. Hello, Mr. Grant. Good morning. So we're set to go to trial on Mr. Grant's case a week from Monday, correct?
Correct.
Okay. 80 was how many on the venire Mr. Keach requested to the state?
State to concur with that, Your Honor.
Okay. Mr. Grant, the venire is the jury pool, the people that the jury are selected from. So I was asking, how many people did we think needed to be called in for jury selection? I did see the proposed jury instructions and verdict form. I appreciate that a lot. What else do we need to discuss today?
The state did file some motions in limine, so if the court wants to go through those today, we can, or we can wait till the morning of jury selection. I don't think, I've reviewed them. I can certainly get with Ms. Sandler, and none of them are anything unusual. Most of them follow the rules of evidence, so I don't suspect that there'll be anything that requires a lengthy conversation regardless. So I'm fine addressing it on Monday unless the court wants, on the 30th, unless the court wants to do it now and have a proposed order.
This
the state's fine with the morning of jury selection. It's very standard and doesn't address any specific pieces of evidence.
Okay, and so the court wouldn't need to rule on those until after jury selection, correct?
Correct, and I think most of those can be stipulated too, truthfully. So, I mean, I can, actually, the state and I can get together between now and then and go through, and if there's any that are contested, we can just reserve on those until the Monday of jury selection.
I think that's perfect.
Is there any outstanding offer to Mr. Grant?
Your Honor, in an abundance of caution, the state may have an offer to Mr. Grant by Monday. It has to go through the supervision process, but the state anticipates potentially making an offer before Monday.
Okay.
For the record, the defense made an offer to the state Tuesday for consideration. And I think that has been, what's the word, tabled? Or not reviewed in full?
It's not been reviewed in full by supervision, and it just needs to go up the chain with the nature of this case, Your Honor.
Okay. If Mr. Grant wants to enter a plea, you know, he can do that at, well, Judge Gontarek is covering the 12:30 hearings for me a week from today, because I won't be here next week. So I don't know exactly how you would want to enter that plea. I would suggest doing it then, and I'll talk to Judge Gontarek and ask him if that's okay.
If the parties reach a negotiated resolution to resolve this case short of trial, would the court have any objection to us transferring it for the purpose of entry of a plea to a different division?
I wouldn't do that. I would think, I'd just get Judge Gontarek to cover that hearing for me.
Okay.
And I'd like to do it then versus the Monday morning of picking the trial, because then we have all those folks.
Complete. I agree. We'd like to save the expense and the time of the jurors and the court administration's budget.
And that's why the state endeavors to have that answer on Monday, Your Honor, is to give everyone time to make sure that we don't waste resources.
Is there a jury selection on the 23rd? Are there any trials set for the 23rd? Okay.
They're not in this division. No, sir.
Okay.
Okay, just looking at the preliminary instructions. Oh, I didn't see where y'all don't want the instruction regarding questioning by jurors?
The defense does not.
Okay.
I don't know if the state, that's never been anything that seems to make the trial move more efficiently in my experience.
And the state generally defers to the defense for appellate purposes.
I appreciate that. So then, both of y'all, your homework between now and the end of next week is, you know, look at what, if you want the court to give any substantive instructions to either the venire, such as the definition of probable cause or anything else that you want me to give to the venire, or that you want me to give to the jury before opening statements. You know, in civil, they redid those standard jury instructions. We load them up in civil. The instruction in civil says, I intend to give you most of the jury instructions. I think it just frees you up during jury selection, during your opening statements. But I know there's a lot of strategic things that go in there, so it's up to y'all. If you say, nope, we don't agree to that, then I don't give any of the substantive law. I don't want to start off with a mistrial before we get going. So, but talk about that and let me know, okay? I just want to know what my script is to the venire and then before openings.
I can address that now.
Okay.
From our point of view, we would prefer just to go with the standard instructions and not add any substantive instructions and allow the parties during the voir dire or voir dire, however you want to pronounce
Yes,
it,
sir.
to inquire as to reasonable doubt, probable cause, or whatever, you know, presumption of innocence to our respective jurors. So we can.
So you don't want the court to give the definition of probable cause?
No, sir.
Okay.
And may I inquire, Your Honor,
Yes,
does the
ma'am.
defense want the definition of reasonable doubt?
No, I would like to address that through the jury, and I believe reasonable doubt will be addressed in closing instructions, but I would like to be able to address that and not be boxed in as we're, fleshing out what jurors we believe to be a fair and impartial jury in this case.
Okay. Okay, good. So, Mr. Grant, I'll see you no later than a week from Monday on the 30th. Okay? Thank you, sir.
Judge, that concludes my business. May I be excused?
Yes, sir. Thanks,
All right,
Mr.
thank you.
Keach. And again,
All right,
thank you for the jury instruction.
Thank you.
I didn't notate on my minute sheet anything, so these are transported back to Walton County, or is he just going to remain here? I just
Mr.
don't
Keach,
want to tell him to create an issue.
do we want to keep Mr. Grant in Okaloosa County between now and then?
Yes, Your Honor, and I think the order to transport.
Okay, I just
We're-
wanted to make sure I didn't need to write anything on my minute sheet, so that way he's not transported back to Walton County and then it create issues.
I thank you for addressing that, Madam Clerk. Whatever we need to keep him here in Okaloosa, let's do that out of an abundance of caution, because I believe my order, we weren't sure at the time which trial week we were going to be assigned.
I agree.
And Your Honor, I believe he's incompatible with a couple of people, and we'll be in touch with the jail about that.
Well, he is in special housing. He's in maximum security in the second floor, so he's typically in,
So are the people he's incompatible with.
so,
I don't know
well,
if we need an order for that.
I think.
I don't, no, ma'am. I don't do anything as far as
Okay, perfect.
internal workings of the jail.
And I think most of his co-defendants are housed elsewhere, right? So, I don't know if that's an issue.
Thank you.
Thank you.
We're in recess for 10 minutes, and we'll come back and finish up the morning.
All right.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured,
family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire.
Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm Attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Mariah M Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they...
Yes, sir, Mr. Koch.
Yes, good morning, Ms. Reeves. Is Ms. Reeves in 24 CF 187 on? I'm requesting to post this on the 11-12 pretrial docket. And Your Honor, speaking with Ms. Reeves yesterday at the jail, you'll be seeing a motion for to appoint an expert for a copy of this case.
Okay, and you received the information?
Yes, we did.
Okay.
Yes, Judge.
Waiving formal reading?
Yes, Judge. Waive formal reading, enter that not guilty. Yes, Judge.
Thank you. Ms. Reeves, I'll see you no later than November 12th, okay?
And like we talked,
Bond. You were supposed to pay the bond.
remember yesterday, our first step would be that evaluation.
The first time I court implemented it, 5 weeks ago, they said they're going to pay the bond, and it's not done.
The first step is that evaluation we talked about yesterday. That's what we got to get done first, okay? So once that evaluation gets complete, then we can discuss possible bond issues.
Until November.
Let's get the evaluation done. It's top priority in this case, okay? I know.
So Ms. Reeves, I'll see you, it sounds like I'll see you before November 12th, okay?
I hope so.
Yes, ma'am, me too.
God
Thank
bless
you.
Yeah,
Thank you, ma'am, you
you're
too.
welcome.
Nicole Langley is next. She has no attorney.
Ms. Langley's case number is 24 CF 1888. Hello, Ms. Langley.
Hey, how you doing?
Good, how are you?
I'm good.
Does the state have an offer for Ms. Langley?
Yes, if she takes it today, so this offer will leave after today. It would be an adjudication of guilt for time served, forfeit the handcuff key that was found on your person. That would include a dismissal of, just so for her knowledge, because there's only a 2-count information, she was technically charged with 4 counts. That would mean that the obstruction and the evidence the evidence destroying would come off as well. So you would be pleading to possession of controlled substance and any possession of paraphernalia, adjudication of guilt, credit for time served, and you'd be done with that today.
So that would be misdemeanors, both of those?
No, the possession of controlled substance would be a felony, but she has already previously been adjudicated, Your Honor.
Okay. So, Ms. Langley, here's what I hear the offer is from the state, is that you'd be adjudicated guilty of the possession of a controlled substance, of possession of narcotic equipment. The other 2 counts would be dismissed. You'd be adjudicated guilty of those 2 counts. You'd be sentenced to time served, so you can get out of jail today. You'd need to pay the court cost, and I'd ask you for some period of time. How long would you need to pay those costs? If you failed to pay those within a certain period of time, then they'd go to a civil lien or judgment, not any felony, not any criminal thing.
What does civil mean? What does that mean?
Means that it may adversely affect your driver's license, but I would ask you, do you need 6 months to pay the court cost?
Yeah, yes, sir.
Okay. Okay, so do you want to accept the state's offer?
Yes, sir.
Okay, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand out. So, Ms. Langley, if you accept the plea, you're waiving your right to a trial by jury. Do you understand that?
Yes, I don't understand what that means.
Okay, is that there's not going to be a trial if you're adjudicated guilty and sentenced to time served.
Okay, so my stuff will be over with, right?
Correct.
Okay, yes, sir.
Okay, you're also waiving your right to an attorney. Do you understand that? Okay. Have any questions for me or the state?
No, sir.
I just want to make sure, Your Honor, there's also the forfeiture of the handcuff key that was found, so she's going to be getting all of her other personal property back, just that handcuff key.
Okay, I didn't even know I could get charged with it.
And that's based off the fact pattern, that's why I dismissed that charge, but I still want that to remain in the possession of the OCS.
Okay, yeah, I didn't want it back because now, since I know it's illegal, I don't want it.
Right, okay. Yeah.
Okay.
I just want to make sure it's on the record, Your Honor.
So, Ms. Langley, here's what I understand, is that you would be adjudicated guilty of just those 2 charges. You'd be sentenced to time served, so you get out of jail today. You'd have to pay the court cost, and then the handcuff key would be forfeited. You won't get that back.
Okay, yeah.
Is that what you want to do?
Yes, sir.
Okay. I do accept your plea, and that's what you're sentenced to. Ms. Langley, what would the court cost be? $650. How long will it take you to pay the court cost of $615?
I would give it about like what you said,
6 months? Okay, you've got it.
So everything's squashed, right?
Everything.
Okay.
Everything is resolved today.
Okay,
Yes,
yes,
ma'am.
sir.
And they'll let you out today.
Thank you.
Thank you,
Have a
ma'am.
good day, sir.
Thank you, ma'am. You too.
I think she has a case on her name. She has a case on her name and on probation.
Oh, okay. Thank you. And her last name? Raj. Thank you. Got it. Yes, ma'am. Thank you. Hello, Miss Lige.
Hi.
You look like you were just surprised with something.
Your Honor, at this time, based off of a statement by the alleged victim in this case, stating that they do not wish to proceed, they will not cooperate with prosecution, and they want the charges dismissed. The state's going to be announcing a dismissal of 24 CF 1925. This case, Your Honor, was also the basis of a VOP for Ms. Lige. We would also like to dismiss that VOP at this time as well.
Okay. Ms. Lige, I certainly don't see a downside to you for that. So case number 24 CF 1925 is dismissed, and your violation of probation is dismissed.
Your Honor, I did instruct Ms. Lige that she needs to report to probation on that 22 CF case. Her term date for that probation is 2026. So I did instruct her that she needs to report to probation immediately upon her release from custody.
So Ms. Lige, it doesn't, you're still on the same probation you were on before this, okay? So when you get out, make sure you report to probation.
Yes. Report first thing tomorrow morning, after 5. Okay. All right.
Thank you, ma'am. Thank you.
We have Maria Rivera Mejia. She has no attorney right now, Judge.
Thank you.
130.
This is case number 24 CF 1929. Good morning, ma'am.
Good morning.
Does the state have an offer for Ms. Mejia? This is number 11 on the 130 docket.
Your Honor, if I may, just because I had Ms. Maria as a client, she was found incompetent, Your Honor. And this was a case, we had another case that was ultimately dismissed. So I just want to share that with the court, just to, not to, just bring that.
Oh, good. Yes, sir, I appreciate that a lot.
She needs an attorney because.
Okay.
Yes.
Ms. Mejia, do you want me to appoint an attorney to represent you?
I can represent myself, so do you have questions for me?
You don't want an attorney?
He's the public defender before.
Okay. Do you want them to help you on this case?
Yes, sure.
Okay. Thank you, ma'am. I do appoint Mr. Koch to represent you.
Okay.
Good morning, Maria.
Good morning.
Your Honor, receiving the information, will be entered not guilty, wait formal reading, and request it be kept on that 11-12 docket.
Okay.
I'll be sending a motion to this court.
Good.
Get an earlier hearing time.
Ms. Mejia, I'll see you no later than November 12th. Mr. Koch is going to file a motion, and I'll see you then.
So I'm not going home today?
Not going home today, no, ma'am.
So can I say something?
Talk to Mr. Koch first, away from the microphone.
Yes, Maria.
Okay, so when I go check the house for housekeeping.
One second, I don't want to talk about this case. Here's what we'll do. I'll come out to jail tomorrow, so you talk privately. I will definitely see you tomorrow.
I have evidence of they lying pills.
I know, we'll talk about that tomorrow.
Tomorrow?
Yes, ma'am.
Okay, fine.
Thank you, ma'am.
Thank you. Thank you, Judge.
Kirtland McNamara is next, Mr. Klein.
Your Honor, have we been appointed in Mr. McNamara's case?
No, that's no attorney, sorry.
Okay. Mr. McNamara. Mr. McNamara?
Yes, sir.
Good morning, sir.
Good morning.
Mr. McNamara, do you wish for me to appoint the public defender if you qualify financially?
Sir, I was going to ask you if I could have permission to speak before.
Okay, hold on one second. Before you do that, I don't want you to say anything that may hurt your case. Everything's being recorded. The state's back to your right. So if you're going to have an attorney, I think you should get their advice before you say something on the record, okay?
Yes, sir, I understand. I'm not going to say nothing that's, going to criminal me. I just want to, just point something out, Your Honor.
Okay, yes, sir.
So, I wanted to say, okay, when I went to first appearance, Judge Ward read the report at first appearance, and he found no probable cause for the burglary at first appearance. So then he set me $1,000, cash suppression bond for the criminal mischief. So I wanted to say, if there was no, probable cause of a burglary, so why would there be a probable cause of a criminal mischief of a door frame when, this would sound more of a trespassing case, Your Honor? And so I wanted to get this settled today. If we can talk to the state, what we need to do to, get a settlement today.
First off, you did fill out a financial affidavit, and you do qualify for the public defender, so I do appoint them to represent you. And then I'm looking at the docket to address your questions.
Yes, sir. So what I was going to ask also was, if we can't get the state to, make a deal to get this settled today, I want to, state that, I live in the area my whole life. I live at 134th Benton Avenue.
Hold on one second. Hold on. Just stop. I do see on apparently Judge Ward's minutes, it says no PC, no allegation of the defendant being armed or being armed.
I didn't file it based on being armed, Your Honor. I filed it on just a burglary of a structure. I didn't see why it was filed or charged originally as armed either. So I just filed it as burglary of an unoccupied structure.
Records, it says, Judge Ward said he found no probable cause of the burglary or at all, and he sent me $1,000 for just a criminal mischief.
Okay, well, does the state have an offer for Mr. McNamara?
No, we're trying to get the restitution amount. The amount that they gave in the report was really high for a door frame, so I'm trying to get the actual number figured out before I present an offer.
I want to see wrong, because I need to be out there for my mom. I'm working, I got an address and, all that, so I want to ask.
If the court would give me just 1 second.
Yes, sir.
That's fine. So it looks like it would be appropriate for the court to set some kind of a bond on count 1 in the information. The first appearance paperwork does show there was finding no probable cause, specifically to the allegation of being armed. The state obviously has subsequently filed an information charging Mr. McNamara with good old-fashioned burglary of an unoccupied structure. I do believe the court should set a bond on that count, because I don't believe one currently exists on count 1. Mr. McNamara would request a signature bond on that count.
Okay, to the state?
She turned on, she thinks I'm going to the state.
I'm okay with converting the cash professional account 2 to a signature, but I want $2,500 signatures on both. So for a total of $5,000 of signature bonds.
Okay.
So
Any objections?
today, so I can go back to work today.
No objection from Mr. McNamara, Your Honor.
Mr. McNamara, so your bonds are $2,500 signature bonds. So you'll be able to sign for those without putting up any money? They'll let you out of jail today? If you fail to appear when you're supposed to or commit a new law violation, you'll owe $5,000.
Yes, Your Honor. Thank you so much, Your Honor.
Okay, so hold on
Your
one
Honor,
second.
I
Yes,
am writing on the information for Mr. McNamara the fact that his next court date is November 12th at 9 o'clock. Mr. McNamara, you need to be in court on November 12th. Please call me beforehand, okay?
Yes, sir. Thank you so much.
Mr. Pines, you're entering a denial.
I don't know if he actually is or not.
Thank you. Your Honor, we will waive the formal reading, acknowledge receipt of the 2-count information, enter not guilty plea.
Thank you, sir.
Scott Hughes is next. For Mr. Lynn.
Can you just make sure we don't get a continuance? Speedy trial.
Yeah, absolutely. I'm just going to enter not guilty plea and sign it. Okay.
November?
That's the next court date. Okay. Your Honor, this is Mr. Mose. He is present in 24 CF 1886. We do have a 3-count information. We will waive the formal reading, enter a not guilty plea, and just ask that this remain. It's been previously set on November 12th. I will tell the court, we'll try to get Mr. Mose back in front of the court in the month of October for some kind of a resolution here, if he's okay with that.
That'd be great.
Good.
Yes, please.
Mr. Mose, I'll see you no later than November 12th, but hopefully I'll see you before that.
Thank you, Judge Brown.
Thank you, sir.
As soon as I know something.
Joshua Paulson is next, who has a no attorney.
I'm sorry, Price? Paulson, got it. Hello, Mr. Paulson.
How you doing, sir?
Good to see you again, sir.
Yeah.
Thank you. Mr. Paulson's case is 24 CF 1939. Mr. Paulson, do you want me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
I get a disability check, a SSI check, $903 a month.
Okay, I do appoint the public defender. Mr. Koch is approaching on your right.
Okay.
Good morning, sir. Your Honor, receiving the 3-count information will be entered not guilty, waive formal reading, and request to be kept on that 11/12 pretrial docket.
Okay. Mr. Paulson, I'll see you no later than November 12th. But if Mr. Koch wants a hearing before that date, I'll see you then. You got a haircut since I saw you last time.
November 12th, you said?
Yes, sir.
All right, thanks.
Thank you, sir.
All right, so I'll talk to you.
Yes, sir. I'll see you at the jail, absolutely.
I said Kyle Scott with Mr. Cobb.
Good, thank you. Hello, Mr. Cobb.
Hi, Judge. How are you?
Doing well, thank you. Hello, Mr. Scott.
How's it going?
Mr. Cobb is on Zoom, okay?
So, am I, sorry.
Hold on, let him talk first, and then if you have a question.
Yes, sir.
Okay, Mr. Cobb?
Yeah, Judge, when I got the order of appointment the end of August, I filed a written plea of not guilty on behalf of Mr. Scott. So I thought it would already been passed on November 12th, but I have already entered a written plea of not guilty on his behalf.
Okay. So that means that I'll see Mr. Scott no later than November 12th, but if Mr. Cobb files a motion before that, or if the state offers you something that you want to accept before November 12th, then I'll see you then. But Mr. Scott, just know that, I know you want to say something. Everything's being recorded. If you say anything factually about your case, it can be used against you.
Yeah, no, I was just gonna ask so, all right, the charges for the stuff, for whatever paper they handed me right here with the motorcycle stuff, the GTA and the dealer and stolen property, that was in Crestview, and then the driving on suspended third and sequential and the paraphernalia was in Shalimar. So is all that merged together and now I'm just coming for Walton Court?
It's all going to be handled, I believe, in Judge Brown's division, and I'm on both of those cases. I've been appointed to represent you on both those cases.
So that is as one whole, all that is as one whole?
It's two different cases, but they're both before me, and Mr. Cobb represents you.
Okay, that was the question.
The Crestview case.
Yeah, and I'm scheduled to come see you out of jail.
That's the question, that's the question.
Good.
Yeah,
Thanks,
thank
Mr.
you.
Yeah,
Okay, so
and-
November 12th.
Mr. Scott, I'm coming to see you at the jail tomorrow. I have it on my calendar.
Cool, thank you. November 12th,
All right.
next court date?
Yes, sir.
Thank you.
Thank you.
I have Eileen Yepes as well with Mr. Cobb.
Okay, thank you.
Yeah, Judge Jason Cobb, on behalf of Ms. Yepes, I filed a written plea of not guilty just a little while ago, about, I don't know, 20 minutes ago, but I'm scheduled to see Ms. Yepes tomorrow, and I have both of her cases, and I'll talk to her about the new case, and I'll explain to her what's going on in the older case, and we're in the process of getting depositions rescheduled at this time, so November 12th would be great.
Okay. Ms. Yepes, I'll see you no later than November 12th. Mr. Cobb will come up and see you in the jail. Like your hair.
Thank you.
Looks really good. Thank you, ma'am.
Daniel Tingle with Mr.
All right, thank you, Judge. I believe those are the only two I have.
Thank you, Mr. Cobb.
Okay.
Judge, this is Mr. Daniel Tingle before the court, 24 CF 1435. This is on the 130 docket for arraignment. I know we're trying to work this case out. I believe Mr. Snell needs additional time to try to contact the victim. Can we leave this at 1:30 just in case we can line this up for today?
Yes, sir. Sounds good. I'll see you at 1:30.
Yes, sir.
Thank you, sir.
We're going to recall Allison Snipes from the 9 o'clock docket.
Okay, thank you. Okay, gotcha. Good, thanks. Mr. Gotch?
Judge, thank you. This is Mrs. Snipes. Speaking with the state attorney, and of course, on the record, I told you this morning, we were told a time-sensitive offer. The state is willing to keep that offer on the table till next week, next Thursday. So, Your Honor, if we can ultimately continue this, I guess, on the 11/12 docket, but Thursday, I'm gonna talk to my clients at the jail, and if they want to take it, I'll bring them in for I know our Thursday dockets, but the offer is on the table till Thursday.
Okay. Mr. Cox, so I'm not going to be here next week.
Oh, okay.
So Judge Gonteric is covering my 12:30 hearings, if there are any. Email me directly, I will have that access. No later than Wednesday. It'd be nice to get it before that, because then I need to make sure that somebody's here for Ms. Snipes to enter a plea in front of.
Yes, Judge.
Okay. Ms. Snipes, I'll see you no later than November 12th if the state doesn't offer you something before that.
Okay,
Thank you, ma'am.
thank you.
Keep it.
Okay,
All right?
okay.
Parker Stewart is next.
Judge, yes, this is Mr. Stewart in three cases. Same situation. The state attorney is going to keep the offer open and available for a week, giving us time to have meaningful private discussions. So requesting the case ultimately be put on that 11/12 docket, but knowing in the back of our mind, we're going to talk and discuss about that offer.
Okay. Thank you, sir.
Yes, sir. Keep that with you. Yes, sir.
Carrie Stone.
In the 11/12 date, though,
Yes.
even if you have Judge or on next week, let's say we set it for a 12:30 hearing.
Yes, sir.
And we don't get it worked out, I can ask the court to set it for a VOP evidentiary hearing.
Absolutely.
Whatever your, like in October, your hearing date.
Right.
Okay.
If you don't come back next week to enter a plea, then just email me and say that you want to set the VOP and we'll get it scheduled.
Okay, thank you.
Good, thank you.
Thank you, Judge. This is Mr. Stone. On the 6 cases in front of you, same scenario, Your Honor. The state attorney is going to keep that offer open and available for a week, allowing us time so we can have some discussions.
Okay.
And ultimately, this case we put on that 11/12 docket, Judge.
Okay, thank you, sir.
Thank you, Judge Brown.
Yes, sir. I'll see you soon.
I believe Mr. Klein wanted to address David McLeod in the 2:30 docket.
Okay.
Your Honor, this is David McLeod in 15 CF 2415. He is on the 2:30 docket. I did meet with Mr. McLeod at the county jail yesterday. I know what motion he wants me to file, and until very recently, I was unaware that Mr. McLeod has been filing pro se motions pretty much since his conviction back in 2016. I now know how I have to style that motion. After meeting with him, I specifically told him this cannot be filed under certain rules of criminal procedure. In discussing this with him, this is going to be a straightforward motion to dismiss based on some case law prior that's previously been issued by the 4th District. Mr. McLeod did tell me that he would be okay if I asked for a continuance. I couldn't file the motion basically because there's already been rulings denying the substance of the claim, but I don't think he properly sought relief the way he wants me to. So if the court would continue this to the October 10th docket, I will get that motion filed probably on Monday. I don't expect it's going to be lengthy in any way, shape, or form, but just for record reasons and giving Mr. McLeod a chance to maybe appeal this if the motion's denied, I do need to ask for that continuance. And I did advise Mr. McLeod yesterday that the state's offer initially was 10 years in the Department of Corrections. They would, if he wanted to accept the offer today, they would agree to 5 years, but he would have to waive his credit prior to March of this year. Mr. McLeod has rejected those offers. So we are moving the case forward. I was totally unaware that there had been previous motions that he had filed previously, which caused actually an ethical issue with me, so.
Okay. Do you need it in the afternoon?
No, I think it could be in the morning. I will do everything I can to put all of my arguments in writing, so I don't expect there to be a lot of supplemental discussions.
Okay. Mr. McLeod, I'll see you on October 10th. Thank you, sir.
David, I'll come up with
That's all I have.
Okay.
Your Honor, I had Christopher Blair on the morning docket, and I've called Mr. Blair multiple times. And basically instructed me to report to probation. I had to leave messages. I don't know where he's at. I haven't seen him since last week.
He's not on probation.
State would request a KP, Your Honor.
KPS is issued for Mr. Blair, and the first appearance judge will determine the bond.
Well, can the state request that he be held without no bond? Just because, I mean, he essentially absconded from probation. He hasn't been able to get up with his probation officer whatsoever. And so I think that's